Okay, let's unpack this. Innovation. It often walks a tightrope, doesn't it?
It really does.
Especially when regulation uh, steps into the picture.
Mm-hmm.
And nowhere does this feel more relevant than, well, when we're talking about nicotine delivery devices.
Absolutely.
Today, we're diving deep into a fascinating legal battle. ITC Limited versus the Controller of Patents.
Yeah, this one's interesting.
A recent decision by the High Court at Calcutta has sent ITC's patent application. What was it called again?
It was for a device and method for generating and delivery of a nicotine aerosol to a user. Quite a mouthful.
Right. And it's been sent back for fresh consideration.
Uh-huh.
What's fascinating here is, well, why?
Exactly. So for this deep dive, our mission is pretty clear. We're going to dissect the core arguments, understand the court's reasoning,
Get into the weeds.
and really explore what this all means for patent law in India, especially when public health concerns pop up.
And for you, our listener, who actually shared some initial notes on this, thanks for that, by the way.
Yeah, good stuff. We're going to get into the nitty-gritty of what the court actually said and, importantly, why it matters.
Okay.
We'll be drawing on the court's judgment itself, naturally, and also a really helpful briefing document that kind of summarizes the key bits.
Perfect. All right, so let's get right into the heart of it, the invention itself. What exactly was ITC trying to get a patent for?
Okay, so the core of ITC's invention is this device. It generates a nicotine aerosol, right? But here's the key thing. Purely through a chemical reaction.
Chemical, not like heating or electronics.
No, none of that. No electrical components, no heat. That's a really key distinction they made, trying to separate it from e-cigarettes or, EDS.
Right, EDS, electronic nicotine delivery
Yeah.
system, so no batteries, no coils.
Exactly. Think about it. Totally different mechanism.
Huh. Chemical reaction? That immediately sets it apart. Tell me more. How did that actually work?
Well, according to ITC's description, the device uses this specific setup, a configuration where you have at least two components arranged parallel to each other.
Okay, parallel.
Yeah. One has the nicotine, or alkaloids, and the other holds what they call an aerosol-promoting substance. In this case, it was pyruvic acid.
Pyruvic acid, okay.
So when the user inhales, these two things react at a specific point.
Just from the airflow.
Apparently so. That reaction generates a nicotine salt-based aerosol, which is then delivered to the user.
Wow. So yeah, a completely novel approach, bypassing the usual electronic heating.
Which, as you said, has potential regulatory ramifications, which we definitely saw play out.
So again, no batteries, no heating coils. That is a pretty fundamental difference from what most of us picture when we think of, like, vaping.
It is.
But what did the controller of patents make of all this seemingly unique tech?
Well, the controller, they took a different view. They basically suggested that how the aerosol was generated didn't really change the fundamental nature of the device. Meaning it still delivers nicotine, and therefore, in their eyes, it was, similar enough to e-cigarettes or ENDS.
Despite the lack of electronics.
Despite that. And they also sort of categorized it under nicotine replacement therapy, NRT.
NRT, like gums and patches.
Kind of. Implying its intended use was maybe to help people quit smoking by replacing that nicotine intake.
Okay, interesting classification. And I remember reading there were concerns about the actual amount of nicotine this device could deliver.
Oh, absolutely. That was a big one. ITC proposed a nicotine concentration of 60 to 90 microliters per tube or channel.
60 to 90.
Yeah, with an estimated delivery of 0 to 15 micrograms per puff.
How does that compare?
Well, the controller flagged this as a significant concern. They pointed out that these levels could be seen as very high, potentially exceeding the permissible limits for nicotine in things like gums, lozenges, strips under the Drugs and Cosmetics Act.
Which are much lower, right?
Much lower, typically around, say, 2 to 4 milligrams total in those products. So, yeah, even with this new delivery method.
The fundamental health debate around nicotine is still front and center.
Exactly. It seems inescapable.
Okay, so the controller wasn't just questioning what the device was, but also the potential health implications. The nicotine dose.
Right.
That brings us neatly to the grounds for rejection, specifically Section 3B of the Patents Act. What exactly does that section cover?
So Section 3B of the Patents Act, it essentially says that certain inventions just aren't eligible for a patent.
Which ones?
Things that are contrary to public order or morality, or, and this is key here, things that could cause serious prejudice, serious harm to human, animal, or plant life or health.
Okay, so serious prejudice to health. That sounds like the relevant part here.
Precisely. This section is often the battleground where public health concerns directly clash with, well, inventive ambition.
And the controller's argument was basically that ITC's device fell squarely into this serious prejudice category because nicotine is addictive and has known health risks.
Exactly that. The controller explicitly stated they were convinced, they were satisfied, that ITC's application didn't comply with Section 3B.
And they brought evidence.
They did. To support this claim of serious prejudice to health, they referenced the ICMR white paper.
Ah, the Indian Council of Medical Research report.
That's the one. The paper that famously recommended a complete ban on e-cigarettes and ENDS.
So they were linking ITC's device to those, despite the technical differences.
I'm now drawing that parallel, yes.
But IDC didn't just roll over and accept this, did they? They pushed back on this interpretation of serious prejudice.
Oh, definitely not. They had a strong counterargument. ITC argued that you can't just look at the phrase serious prejudice in isolation.
What context did they want?
They said it must be interpreted in the context of the invention's primary or intended use.
Okay, the intended use. How does that change things?
Well, their point was maybe the intention wasn't harmful in the way the controller suggested. They even pointed to, apparently, a presentation by a deputy controller of patents suggesting that Section 3B hadn't historically been applied to inventions related to tobacco or nicotine anyway.
Really? That's interesting. So they were arguing precedent, almost.
Sort of. Their main thrust was you can't just look at nicotine itself. You need to consider how this specific device is intended to be used and whether that specific use meets the legal threshold for serious prejudice.
Okay, interesting distinction. Not just the substance, but the application. Now, this leads us to what really seems to be the pivotal point of the case, the procedural fairness argument.
Yes, this was absolutely the crux. This is why ITC ultimately succeeded in getting the rejection overturned, at least for now.
So what was their core complaint about the procedure?
Their main contention was that the controller, in the final rejection order,
Right at the end.
yeah, right at the end, introduced several new documents and legal provisions that hadn't been properly flagged earlier.
Like what?
Most notably, that ICMR white paper we mentioned, but also various acts, the Environment Protection Act, the Drugs and Cosmetics Act, even the E-Cigarette Prohibition Act.
Wait, these weren't mentioned in the first review, the first examination report.
ITC argued they weren't part of the FER, no. And crucially, they weren't fully detailed in the hearing notice either.
So ITC essentially felt ambushed. Like the goalposts are moved right at the finish line, leaving them no real chance to respond properly.
That's exactly their argument. This lack of prior notification, they said, fundamentally denied them a fair opportunity, a fair hearing. They couldn't understand and address all the grounds being used for rejection because some grounds popped up too late.
And they specifically called out the ICMR paper again.
They did. They acknowledged it was mentioned in the hearing notice, but argued it wasn't cited back in the FER, and the full scope of how these other legal acts were being used against them wasn't clear until that final order landed.
Okay, that sounds like a serious procedural complaint. How did the controller defend their process? What was their side of that?
The controller's defense was, well, perhaps a bit thin in the court's view. They basically said all the documents and statutes they relied on were publicly available.
Like on government websites?
Yeah, publicly available government websites, statute books. And regarding the ICMR report specifically, they just reiterated that it was mentioned in the hearing notice.
Implying ITC should have just known. Or looked it up themselves.
Kind of. Implying they should have been aware of its contents and implications just from that mention.
But the High Court, they didn't buy that justification, did they?
No, they didn't. They sided squarely with ITC on this crucial point.
What did the court say exactly?
The High Court specifically found that the controller did, in fact, deny ITC a proper opportunity. An opportunity to address all the documents and the specific acts that formed the basis of that Section 3B objection.
So the mention in the hearing notice wasn't enough.
Apparently not considered sufficient detail. The court even cited a landmark case, the Sangyong engineering case.
Oh, yeah, I know that one.
Right, which basically established that fairness demands all parties get a chance to address the evidence against them. You can't rely on stuff you haven't properly put to the other side.
So introducing new grounds, or extensive reliance on documents, only hinted at earlier, right at the final decision stage. That undermines natural justice.
Precisely. The court emphasized that the specific acts that were key to the Section 3B rejection just weren't explicitly laid out in that hearing notice, preventing ITC from fully arguing against their application.
Okay, so this is really important. The court's decision wasn't actually about whether the invention deserved a patent under Section 3B or not,
Not at all.
but rather a ruling on the fundamental fairness of the process, the way it was rejected.
Exactly. That's a really significant distinction to grasp here. It was about due process.
Now, ITC also raised another important point, didn't they, about the difference between getting a patent and actually being allowed to sell the product.
Yes, that was another key plank of their argument.
What was their reasoning there?
ITC argued, quite logically I think, that obtaining a patent doesn't automatically grant them the right to commercialize the product. That's step one, maybe.
Right, IP protection versus market approval.
Exactly. They emphasize that commercialization is an entirely separate issue. It's governed by a whole different set of laws and regulations, manufacturing rules, sales restrictions, public health regulations, you name it.
So just because you have a patent doesn't mean you can start selling it tomorrow.
Not necessarily, no. They even reference international agreements like TRIPS and the Paris Convention.
The big IP treaties.
Right. Arguing that those agreements suggest patentability itself shouldn't be denied just because the commercial use of an invention might face restrictions or need other approvals down the line.
That makes a lot of sense. A patent protects the idea, the invention itself.
The intellectual property.
Not necessarily the permission slip to bring it to market.
Yeah.
And it sounds like the court agreed with this principle.
They did, absolutely. The High Court explicitly stated that a patent shouldn't be refused simply because the sale of the patented product might be subject to restrictions under domestic law.
So you separate the patent grants from the commercial reality.
That seems to be the court's view. They even pointed to Section 83E of India's own Patents Act, which reinforces this idea that granting a patent doesn't stop the government from taking necessary measures to protect public health later on.
Okay, so the patent grant and public health regulation can coexist in principle.
According to this judgment, yes.
Okay, so after considering all these arguments, the invention's nature, Section 3B, the crucial procedural fairness point, and this patent versus commercialization distinction, what was the final verdict from the High Court? What happens now?
So the High Court ultimately did two main things. First, it set aside the controller's rejection order, wiped it off the books.
Okay, the rejection is gone.
Gone. Second, it remanded the matter, basically sent it back for a fresh consideration.
Back to the patent office.
Back to the patent office. But crucially, they directed that this new examination must be conducted by a completely different officer.
Not the same one. To ensure impartiality.
Presumably. And they put a timeline on it within the next 6 months.
Yeah. 6 months for a fresh look by a new examiner. And the court gave specific instructions to this new officer.
Yes, very clear instructions. The court made it absolutely clear that this new officer has to make their own independent decision.
Start from scratch.
Pretty much, without being influenced by the current court's observations on the merits, only on the procedure.
So the court didn't want its procedural ruling to prejudice the substantive reexamination of the patent application itself.
Exactly. They explicitly stated the new officer should approach the reexamination with essentially a clean slate regarding patentability under Section 3B.
Okay, so what's the real significance here? What are the broader implications?
Well, the real significance, I think, lies firmly in its emphasis on procedural fairness, particularly in these complex patent examination cases where public health is cited as a reason for rejection.
It sets a standard for how these objections need to be handled.
It really underscores the critical importance of transparency and, well, due process, giving the applicant a fair shot to respond to all the arguments.
Right.
And it also just highlights that ongoing delicate balance, that tension between wanting to foster innovation on one hand and needing to protect public health on the other.
It's a constant tightrope, like you said at the start.
So just to really boil it down for everyone listening, the court was not endorsing ITC's invention. It wasn't saying this device should get a patent.
No, definitely not making a call on that.
Instead, the ruling focused squarely on the fact that the process used to reject the patent application wasn't entirely fair. That's the absolute key takeaway, isn't it?
That's the core of this particular judgment, yes. Procedural propriety.
This whole situation, it really raises some pretty fundamental questions for you, the listener, to consider, doesn't it? How do patent law, public health regulations, and these essential principles of procedural fairness, how do they all intersect? Especially when we're dealing with potentially controversial technologies like this. Yeah, and it makes you wonder, what are the wider implications? This focus on procedural correctness. What does that mean for other patent applications in sensitive areas? Medicine, biotech, maybe even AI.
That's a great point. How should patent offices, going forward, balance that need for really thorough examination, especially on health grounds?
With the fundamental right of applicants to have a full, fair opportunity to respond to every single ground of rejection. It's a tough balance.
It really is. Definitely some crucial points to ponder there if you are interested in digging deeper into this stuff.
Where should people look?
Well, we'd suggest maybe exploring Section 3B of the Patents Act in more detail. Also, looking into the core principles of natural justice in administrative law, that's the legal field dealing with fair procedures.
And of course, just staying informed about the ongoing discussions and regulations around nicotine delivery systems generally. It's a fast-moving area. Ultimately, I think this case just serves as a really powerful reminder, doesn't it, of that dynamic, often intricate relationship between innovation, the rules we set around it, and the legal system that has to interpret those rules.
And it really underscores that even when we're talking about critical issues like public health, upholding the integrity of the legal process itself is, well, absolutely paramount.
Couldn't agree more. Process matters.